Good afternoon to all our webinar enrollees or attendants, or I don't know what you're going to call them, but a very hearty welcome to everybody that has enrolled for this webinar on our Conveyancing Update Developments 2017. This webinar is mainly pointed to the direction of new developments that occurred during 2016 that's affecting our conveyancing practice and procedure in 2017. Although we're already further than halfway into February of this year, a lot of these aspects that we're going to address today affect our day-to-day preparation of deeds and documents for purposes of drafting and drawing of documents. As I said, the aim of the seminar is to provide an update. Please as well, each topic that I am going to deal with, and they're numbered 1 to whatever the number is, I am going to refer to authority that substantiates it. And I want to, right from the outset, say to you, please guys, don't, when going to the deeds office and arguing a point, say to the registrar of deeds or the assistant or the deputy or the chief deeds controller or senior examiner, tell him, but Alan, I heard on Alan West's webinar that this is the practice. I am not an authority for a registrar of deeds. Each registrar of deeds is autonomous. However, a registrar is bound in terms of Section 3.1 of the Deeds Registries Act to conference resolutions, obviously to case law, to chief registrar circulars, and the like. So, as I've said, I'm going to refer every time to authority to substantiate the point that I'm making. Without further ado, the first item that we're going to touch on is the registration of a right of habitatio. Now, ladies and gentlemen, as far back as 1951, it was practiced in the deeds registries that when you are registering an habitatio, you cannot register an habitatio over the whole of the land. An habitatio can only be registered over a dwelling. And in 2012, and then again in 2014, the registrars at their annual conference said that to register a habitatio over a dwelling, you need a diagram, not for the dwelling, but for the land on which the dwelling has been erected. So that portion of the land to link up with our cadastral land registration system, you need a diagram for that. That created and caused much costs, specifically in the low-cost housing, the RDPs, where people died, left the property to the children subject to habitatio in favor of the mother. The cost of procuring a diagram could even be equated to the value of the property, and therefore the registrars brought it back in 2016, and they withdrew Conference Resolution 21 of 1951, 29 of 2012, and 31 of 2014, and said, if a habitatio is seeded in respect of a building on a piece of land, no diagram will be required if that building is the only building on the land. The fact which the conveyancer must confirm. Now, immediately I want to say to you, ladies and gentlemen, how are you going to confirm, unless you've done an inspection in loco of the property that you're transferring or for which you're registering the habitatio, that there's only one dwelling on the property? It was an open question, and therefore I have discussed it at length, and the conclusion that we've come to is, from the profession side, you will have to get an affidavit, preferably from the bare dominium owner and the holder of the habitatio, that this habitatio is in respect of the dwelling, and that is the only dwelling on the land. Should there be more than one dwelling on the land, obviously they wouldn't be able to give these affidavits, in which case you will have to procure a diagram so that legal certainty can be afforded in respect of the real right that is being registered. Now, these two affidavits, the big problem is, with a notarial session, if you're creating this habitatio in terms of a notarial deed, you will be keeping that in your protocol. But let's go from the premise that you're creating it in your power of attorney now. You're transferring the property subject to a right of habitatio in favor of the surviving spouse. In 5 years' time, your file does not need to be there anymore, so you can destroy your file. However, usually the problems arise later than 5 years. And how are you going to prove, if something does occur, that there was only one dwelling house on the property when this habitatio was registered? For that reason, we deem it prudent that you lodge the affidavit from the holder of the habitatio and the affidavit from the bare dominium owner, and give that to the registrar of deeds as supporting evidence for purposes of this practice which the registrars have now introduced. Please also remember that if you're registering a right of habitatio over agricultural land and it is for a period of longer than 10 years or the lifespan of the person, then you will have to lodge the consent in terms of Act 70 of 70. I do trust that this new practice and procedure with regard to the registration of habitatios is afforded a bit of relief for us, and we will know how to protect ourselves as conveyancers when registering a habitatio over agricultural land or over urban property. Sectional titles, ladies and gentlemen, we haven't got a problem. Why not? Because a dwelling will be depicted on your sectional plan. So you'll never need these affidavits in respect of a sectional title unit, because the sectional title unit will be referred to or reflected on your sectional title diagram, or sectional title plan rather, not diagram. The next item is estate transfers and foreign marriages. Now, ladies and gentlemen, it has been the practice for a long time that where property is transferred by an executor in the estate of a person who is married, which marriage is governed by the laws of a foreign country, then if the property forms an asset in a joint estate, the surviving spouse must join in transferring the property unless one of the exceptions to Section 21 of the Deeds Registries Act is applicable. This means that if your property is registered in Allen West, identity number, married, which marriage is governed by the laws of a foreign country. In the past, registrars of deeds allowed the conveyancer to certify that the property is not an asset in the joint estate. This practice has now changed, and registrars of deeds said, conveyancer, how do you know what the laws of that country is to determine whether the property is an asset or whether the property is not an asset? Only, and in terms of Registrar's Conference Resolution 5 of 2004, the proof can only be afforded from the foreign mission of the relevant country or an opinion from an expert to that effect that no joint estate is involved. Expert to that effect could be somebody, a professor specializing in international private law, or a legal opinion in that regard. Legal opinion is sometimes frowned upon. So what we're actually saying, it'll be something from the ambassador of the country, the foreign mission, or a professor specializing in international private law. And as I said, except if the executor is also the surviving spouse, unless the person to whom the property is transferred is the surviving spouse, unless there's massing and adiation, unless you are selling the property to pay estate debts, then obviously this practice will not be applicable. And ladies and gentlemen, without being facetious, sometimes it's going to be a very costly exercise and a very tedious exercise to get this proof from the foreign mission. So I was wondering, and I'm leaving it up to you as a conveyancer, why not just join the surviving spouse in transferring the property, ex abundante cotella as just as a matter of overcautiousness, and Bob's your uncle. Then you don't need this unless a very bright registrar of deeds or examiner tells you, but I know that the laws of Zimbabwe is not an asset in the joint estate, which I very much doubt that will happen. But this is something that I am leaving in your discretion to determine whether you're going to join the surviving spouse or whether you're going to obtain this documentary evidence to prove that the property is not an asset in a joint estate. The next item also refers to foreign marriages. Now, ladies and gentlemen, it's always been the practice as well that when you are transferring property from a title deed where the status has changed, meaning I was married out of community of property and now I'm transferring the property as an unmarried person, the Registrar of Deeds wants you to prove the change in status, be it by a death notice or death certificate if the spouse has died. If the spouse has got divorced, you have to lodge a divorce court order, but not only the divorce court order, you also have to lodge the agreement or the settlement agreement, which formed part of the divorce agreement, if divorce order, if there was a settlement agreement. However, if the parties were married, which marriage is governed by the laws of a foreign country, and you're going to prove the divorce in the form of a foreign divorce court order, then, ladies and gentlemen, that foreign divorce court order cannot be certified by you, the conveyancer, or in a notary, or the sheriff of this court, because it hasn't been issued by this court. It must be authenticated in terms of Rule 63 of the High Court rules, or alternatively, if the country is a party to the Hague Convention with South Africa, then you can do it in the form of an apostille by the parties that are allowed to do it in terms of the Hague Convention. This was ruled by Registrar's Conference Resolution 2 of 2016. However, the Registrar of Deeds Pretoria has afforded the permission that she will accept an original divorce court order. If it's signed in the original and you've got the original, then obviously you don't have to go the route of Rule 63 of the High Court rules, or then the Hague Convention authentication route. I hope that makes sense to you, and that you know that orders of court, if it's a South African divorce court order, can be certified in terms of Regulation 20 in bracket 7 by you, the conveyancer, or a notary, not a commissioner of oaths. Please keep that in mind. Regulation 20 in bracket 7, hope you guys are making notes. Regulation 20 in bracket 7 of the Deeds Registries Act only allows a conveyancer or a notary to certify a document of which the original is filed in a government office as a copy of that original, except a diagram and a testamentary document, which I'm not going to elaborate on now any further. Item 4 refers to the acquisition by trustees before appointment. Ladies and gentlemen, this also emanates from previous conference resolutions and case law. And the case law, the Simplex case, as well as the Van der Merwe case, and numerous other case laws we know, said that a trustee cannot enter into a contract in respect of a trust property for a trust still to be incorporated. Just want to elaborate on that. So if the trust has not been registered and the trustees have not been issued with letters of authorization, the trustees cannot enter into a deed of sale for property for a trust still to be incorporated. Not even if you're going to make it subject to a suspensive condition or a special condition that it will be ratified after the appointment of the trustees. The contract is ab initio void. Now, it was the practice, and there's case law to substantiate it, based on our abstract system of land registration, that let's say you entered into the contract for a trust still to be incorporated, and the trustees have been issued with letters of authorization thereafter, and the transfer has been effected in the deeds registry. However, the contract was ab initio void because the trustees did not have that letters of authorization. The case law, as it stood previously, said that because we work with the abstract system of land registration, if it was the intention of the transferor to pass transfer and the intention of the transferee to accept transfer, the delivery of the property is valid. The registrars have changed that. They said in terms of Conference Resolution 4 of 2016, read with the case of Gabriel Lubacini, NO, and Rochelle versus Minister of Safety and Security, 2010 case, all unauthorized transactions by the trustees are invalid. That means that your transaction registered in the deeds registry is invalid. Now guys, this is perhaps a wake-up call to us conveyancers. Do not register property in the name of a trust if the trustees had not been issued with letters of authorization. So that is something that you have to substantiate, because if it should transpire later and the seller or the purchaser gets hold of this conference resolution or this case law and says, hell, I didn't know that transaction was ab initio void, so I'm going to go to court now and I'm going to declare the transaction void, and then I can sell it at a higher price, or I don't want it because there's no building plans, or what. So please, wake up call, conveyancers, to ensure that the land was acquired by the trustees subsequent to their appointment, and the deed of sale must be valid and binding. Once again, please take cognizance of this conference resolution. The lapsing of real rights of extension. Guys, this brings me once again to a practice that conveyancers and conveyancing paralegals and conveyancing typists are not understanding correctly. And in terms of this conference resolution 3 of 2016, it was once again substantiated to say that if a real right of extension has lapsed, either by effluxion of time or because it has exhausted itself, meaning the 5-year period for which it was reserved has lapsed, or all the phases have been exercised, and you're now doing a transfer of a section in that scheme, you do not have to cancel the real right of extension. It has lapsed by operation of law. So all that you're going to declare in your certificate to the Registrar of Deeds, your 15B3 certificate, is that there is a real right of extension. However, that real right of extension has lapsed either by effluxion of time or because it has exhausted itself. However, should you want to re-reserve a real right of extension, and there is already a real right of extension which has lapsed by effluxion of time or because it has exhausted itself, then, only then, do you need to cancel that real right of extension. In the past, we utilized Section 68(1) of the Deeds Registries Act. This conference resolution said, no. You cannot use Section 68(1) because the Sectional Title Act, Section 15, capital B, 1D, provides a specific provision to cancel a real right of extension. So you will utilize Section 15, capital B, 1D to cancel it, but the provisions of Section 68(1) of the Deeds Registries Act will apply mutatis mutandis. Once again, I'm saying, please note that you do not have, you can cancel it if you want to. Nothing prevents you from cancelling it. However, it is not peremptory to cancel it unless you are re-reserving the real right of extension. Cancellation of bonds registered in the name of the incorrect mortgagee. Now, ladies and gentlemen, I don't know if you have been confronted with a problem similar to this, but in terms of Registrar's Conference Resolution 5 of 2016, the registrar said, if you have a bond registered in favor of the wrong mortgagee, how that happens, I don't know. But we know things do happen, and we are confronted at a later stage to rectify it. The registrar said you cannot rectify it in terms of Section 41B. You will have to get the wrong mortgagee, listen to this, the wrong mortgagee to consent to the cancellation of the bond and register a new bond. But guys, remember, we got the provisions of the Insolvency Act that is applicable here, the 6-month period, Section 88 of the Insolvency Act. So all that I'm saying to you, beware, beware, beware. You'll have to inform your instructing financial institution or mortgagee, the correct one, that they are at risk. By cancelling this mortgage bond and registering a new mortgage bond, the 6-month period is going to be of the utmost importance, and they must just be aware. If they feel that it is too much of a risk, you'll have to go to court to have this bond rectified, not in terms of Section 41B, but that the court will then substitute the mortgagee with the correct mortgagee as such. So please, as I said, this should never happen in practice, but we know things do happen, strange things happen, and we are usually saddled with the problem after the fact. Estate transfers emanating from a maintenance claim. Guys, if somebody has died, and be it testate or intestate, and the surviving spouse institutes a maintenance claim against that estate. Let's say they were married in community of property and the deceased left his half share to his mistress, as an example. And she has a maintenance claim against that estate. She has to prove it in court, obviously, and that has to form a liability in your L&D account. But the question posed to the Registrar of Deeds, what proof must I submit to a Registrar of Deeds to prove that this property goes to the surviving spouse entitled to one half share by virtue of her marriage in community of property and the other half share in terms of the maintenance claim? And the Registrar said the causa must set out the full facts. You will lodge a conveyancer certificate in terms of Section 42(1) of the Administration of Estates Act, which says that this property devolves upon her in terms of the L&D account. You do not have to lodge the maintenance claim that was instituted against the estate which was satisfied in the L&D account. So this is your authority, therefore, is Registrar's Conference Resolution 6 of 2016. Item 8 brings us to sales in liquidation and lodgement of bonds. Also, an aspect that examiners, as well as conveyancers, conveyancing typists, paralegals, are not sure of, and the practice has now changed in terms of Registrar's Conference Resolution 8 of 2016. We know that a company that is liquidated can be liquidated in 3 manners. First of all, liquidated by the directors by virtue of a resolution, voluntary, or voluntary under the supervision of the master, or in terms of an order of court. In the latter 2 instances, the bonds do not have to be lodged for disposal in terms of Section 56(1)(b) of the Deeds Registries Act, provided you can prove to the Registrar of Deeds that the company is unable to pay its debts. Now, in the past, Registrars of Deeds allowed the conveyancer to certify that a company was unable to pay its debts, and therefore the bonds need not have to be lodged for disposal. They've changed this, and they said How does the conveyancer know this? So no, the registrars of deeds is not going to accept that anymore. They want a certificate, preferably an affidavit from the liquidator of the company, that the company was liquidated, be it under the supervision of the master or in terms of an order of court, and that such company is unable to pay its debts. So once again, please just take cognizance of this, that you as the conveyancer is no longer allowed to give the certificate. It must be brought by the liquidator of the company. With natural persons, obviously, ladies and gentlemen, the bonds need never have to be lodged for disposal, whether it's a voluntary insolvency or the opposite. The bonds need not have to be lodged for disposal. Lost client's copy and deeds office copy. I do think that my webinar attendees are not only in the Gauteng area, in the jurisdiction of the Deeds Office of Pretoria. However, in 2007, ladies and gentlemen, which I refer to it as the Big Bang, the Deeds Registry in Pretoria lost 400,000 images. We are still suffering the ripple effect of this Big Bang, meaning that the client's copy is gone, the deeds office copy is gone. If it's a deed of transfer, we got some solution. You apply the provisions of Section 38 of the Deeds Registries Act. The problem, however, arises. What happens if it's a notarial deed? Let's say you got married out of community of property, ladies and gentlemen, in 2007. The notary never gave you a copy of your antenuptial contract. You're now wanting to transfer the property. You say you were married out of community of property. They go to the deeds office. Your antenuptial contract was never scanned. What is the solution to the problem? And the only solution to that problem, ladies and gentlemen, and I hope none of you got married in 2007 during the Big Bang, but you will have to go to court to prove that you married out of community of property. This also refers to other notarially executed documents. I'm speaking about lease agreements. I'm speaking about cessions of real rights of extension. I'm speaking about cessions of exclusive use areas. I'm speaking about servitude, notarially attested servitudes. There's no provision in the Deeds Registries Act, similar to Section 38, to have title deeds substituted for those deeds. The registrars of deeds, in their resolutions taken in 2016, namely 9 of 2016, said they will make an exception for a certificate of real right of extension or a certificate of real right of exclusive use area. Not a notarial one, the one that was issued when the scheme was opened. So they say where a certificate of real right of extension or a exclusive use area in terms of Section 25 and 27 respectively is lost, and the deeds office copy is also lost or destroyed, the provisions of Section 38. In all other instances, we have a major problem. And obviously, the main problem lies in the deeds registry in Pretoria, but obviously this could also happen in other deeds registries. I know of deeds registries where there was water damage, the books got lost where the title deeds are housed, rats or mice made nests in the books, and the client lost his copy, and we will also sit with this problem. So please, once again, if it's a 2007 transaction and it's in the jurisdiction of the Deeds Registry and you do get such an instruction, I think you must say a silent prayer when going to determine whether there is a title deed in the Deeds Office. Cancellation of servitudes benefiting the common property. Ladies and gentlemen, the scenario here is there is a sectional title scheme. There is a servitude over the common property, not over the common property, in favor of the common property over other property. So there's a servitude benefiting the common property. Now the registrar said that when you are cancelling that servitude benefiting the common property of a sectional title scheme, listen to what they're saying. They're saying all the bondholders must consent to the cancellation of that servitude, and all the bonds must be lodged. Guys, with a small sectional title scheme of 2 sections, 3 sections, 5 sections maybe, that's possible. If we're working with a sectional title scheme of 150 sections, or in excess of 100 sections, or in excess of 50 sections, and we have to cancel, we would have just started getting all the bonds, and some new bonds will be registered, or some bonds will be cancelled, and lo and behold, some of them might be the 2007 bonds, if you understand what I mean. So this is not an easy task. However, I've addressed it with the Registrar of Deeds Pretoria. We will be referring this to the Sectional Title Regulation Board to come up with some kind of relief, in the sense that there should be a cut-off date for the consents of all bondholders. And surely the bonds do not have to be lodged. We think that this should almost be in line with the provisions of Section 24(6), that the bondholders should be notified, and if they do not respond within 30 days, it is deemed as if they consented to the cancellation thereof. This is all in the melting pot. However, until the Sectional Title Act is amended to provide this relief, we are saddled with this conference resolution. And then, once again, I say, if a instruction like this comes your way, and you must cancel the servitude, and there's more than 100 sections, leave the servitude. It is cancelled, it is no longer applicable unless it is a necessity. Leave it until such time as the Act has been amended to bring relief in this regard. That's just something that I'm throwing out your way. Take it, leave it, use it, don't use it, your choice. Incorrect status in Section 45 applications. Guys, I discussed this resolution at length with the Registrar of Deeds Pretoria, with some of the deputy registrars that attended the conference, with the law lecturers that attended the conference, with the representatives of the Law Society that attended the conference, and I'll name them by names: Jody van Broekhuizen, Mr. John Christie, Mr. Hassan Goga. I said, are you sure this conference resolution as resolved was the correct resolution? And they said, this is the resolution taken. It is the position at this point in time, and unless the Chief Registrar of Deeds suspends this resolution, it is valid and binding. Now, what effect does this resolution have? Ladies and gentlemen, if you're doing a Section 45 application, this is now Section 45 a estate, or Section 45 bis a divorce, or a change in status in terms of Section 45 bis 1 capital A, and you reflect the status of your person acquiring the property in terms of the transfer by endorsement incorrectly. For instance, you describe the person as unmarried, but the person should be described as married out of community of property. Just as an example, the conference said, if your status is incorrectly reflected in your Section 45 application of the transferee, the transaction must be cancelled, or a rectification transfer must take place. Now, I said to myself, a rectification transfer from Alan West, married out of community of property, to Alan West, married out of community of property. It's not possible. If you say to me, go to court and cancel it, must I take the matter to court and cancel it? Ladies and gentlemen, I'm saying this, I cannot go along with this conference resolution, and I'm saying just leave it. It's not going to affect anybody unless the the Chief Registrar is going to suspend this. It will be brought to conference at the end of this year again to revise this based on the authority that Section 41B allows a deed or document which has incorrect information with respect to the description of the parties to be amended. And that was also substantiated in the Chief Registrar's Circular 3 of 1994. So maybe from here going forward, please be aware that or not be aware, be vigilant that the status of your parties in an application in terms of Section 45 is correct. Not such a big problem with a deed of transfer, because there we can do a 41B. With an application which is transferred by endorsement, we cannot do it. So please just be aware of this untenable situation that this conference resolution is going to hold in for us. Partial cancellations of powers of attorney. Guys, I'm sure you on an ongoing basis is confronted with this. You have an associate in your firm who has been afforded the authority to sign cancellation of bonds or whatever the case may be for financial institutions, and that person leaves your firm, or the director dies, or whatever the case may be, and the other directors are still in your power of attorney. The question was, can a general power of attorney be cancelled partially? Meaning, can you release some of the parties from that general power of attorney? And in terms of conference resolution, it was categorically stated you cannot partially cancel a general power of attorney. You'll have to cancel the general power of attorney in toto and register a new general power of attorney with the new parties involved thereto. Item 13, additional amounts in consents. Ladies and gentlemen, there was a bit of confusion in the past. When you're doing a consent to cancellation, a consent to release, a consent to substitution, a cession, all those form MMs, and in terms of the Section Title Act, AMs. Is it necessary to disclose the additional amount in that consent? It was taken to conference, and conference said the additional amount does not have to be mentioned in your consents. However, should it be mentioned, it must be correct, because if there's an error in that amount, you're going to pick up a rejection. So it will be treated as pro non scripta if you include it. However, if you don't include it, that's fine. So what am I saying to you? Rather be proactive. Don't put in that additional amount, because you just could possibly pick up a rejection by setting it out in words and figures, and the words do not correspond with the figures, or the amount was incorrectly transcribed from the mortgage bond, etc. So in future, just leave out the amount from your consent to cancellation, to release, to cession, or whatever the case may be. It just makes life much easier for us and the examiners in the deeds office. Item 14, lapsing of a preemptive right. Ladies and gentlemen, this item emanates from the 8-year preemptive right with regard to RDP properties. Now we know there is a condition in your title deed that said the property may not be sold within 8 years from date of transaction or date of registration. The wording sometimes differs from what period of time the 8 years starts, but you will have yourself led by the wording of the condition. Now the question was, if that 8-year period has already expired, however, the property was sold while the 8-year period was alive and kicking, can I transfer the property and bring a Section 68(1) application to cancel it because it has lapsed by a fraction of time? Or must I still lodge the consent because the property was sold during the 8-year period? The registrars of deeds said the property was sold during the 8-year period, therefore you have to lodge the consent. Now, in practice, that might make sense to you, but you go to the relevant department and you ask them for the consent for the lapsing of this condition, and they say, why? It was from date of transaction, which was 2005. It is now 2017, and now you're asking me a consent to cancel the condition? It's lapsed by a fraction of time. Now you tell them, but he sold the property. They say, we don't know when he sold the property. The condition is not relevant anymore. He could have sold the property during that period, so we're not going to give you a consent. So you're sitting once again between the devil and the deep blue sea. What do? The alternative is to first lodge for the cancellation, because it is lapsed by a fraction of time, wait for the title deed to be delivered, and then transfer the property. That is a manner to overcome this impasse. Whether it is good conveyancing, whether it's bad conveyancing, ladies and gentlemen, I'm leaving that up to you. But one has to sometimes look for a solution to a problem where there is no solution. And I found that this was the solution to the problem. Foreign trusts. I'm going to touch on foreigners a bit later. However, in terms of Conference Resolution 17 of 2016, the registrars held that any property being acquired by a foreign trust, or any property, or not property, any mortgage bond registered in favor of a foreign trust, that foreign trust, in terms of Section 8 of the Trust Property Control Act 57 of 1988, must first be registered with the Master of the High Court before any trust can acquire the property or register mortgage bonds. Now, once again, this brings us back to that other case that I referred to. If you're going to register this property in the foreign trust without the foreign trust being registered with the Master of the High Court and letters of authorization, that case law which we said, not only the underlying legal document is invalid, the ultimate transfer of the property into the name of the purchaser could also be invalid. So what are we saying? Beware, beware, beware. Foreign trust must be registered with the Master of the High Court. It must be afforded the necessary registration number, and as far as I could deduce from the Master of the High Court, it will get a IT number, meaning an inter vivos trust. It obviously cannot have an MT number. Transfers of by deed of transfer instead of Section 40 of the Administration of Estates Act. Guys, I've been privy to many of these where the transfer, or let me give you an example. I die and I bequeath my property to my children. Should the youngest be under the age of 28, the property must be administered by my trustees. What does this entail? It entails a mortis causa trust, which can only be transferred, and I'm using transferred in inverted commas, can only be handed over to the trustees by way of an endorsement in terms of Section 40 of the Administration of Estates Act. If you do it by virtue of a formal deed of transfer, the registrars of deeds said, the matter will have to be rectified. Either the property must be transferred back to the deceased, that means you have to do a rectification transfer from the trustees of that mortis causa trust back to the estate of the deceased, and then you'll have to do a Section 40, or you'll have to go to court. Now, the first question that I ask myself is, who's going to take this matter to court? Who's going to do the rectification transfer? You've transferred the property by virtue of a formal deed of transfer. It's in the name of the trustees for the benefit of the beneficiaries. I don't know. However, the the registrars put a proviso to it. They said, however, the error need not be rectified if proof has been submitted that all the terms of the trust deed has been met. Guys, this is an open open-ended question. I don't know what terms of the trust deed has been met. Does that mean that the beneficiaries have reached the age of 25 or 28 or whatever the case may be, and they are now entitled to the property? If they haven't reached that age, does that mean they first have to go to court? Or I'm not sure what proof, who's going to provide that proof? I don't know. What this tells me is I will not in future do it by virtue of a deed of transfer, even though it is requested from me. I know that Section 40 of the Administration of Estates Act is peremptory, and therefore I can only do it in terms of Section 40, because this is going to come back and bite me somewhere where I do not want to be bitten in future. Date of transaction in transfer duty receipts. Guys, if you're going to pick up a rejection in the deeds office, it's going to be with this one. The registrar said, if you're creating a negative personal servitude in your power of attorney in favor of a third party, I'm not speaking about a negative personal servitude in favor of the transfer. You're creating a negative personal servitude in favor of a third party. We know that in terms of the last proviso to Section 65 of the Deeds Registries Act, that negative personal servitude must be accepted by the person in favor of whom it is being created, the enforcer thereof. And over and above that, unless it is exempt from transfer duty because it's a municipality or whatever the case may be, you must lodge a transfer duty receipt for that transaction whereby you creating this negative personal servitude. And when I'm speaking about this negative personal servitude, it's usually these homeowners association conditions that you're creating in the power of attorney. Now, the date of transaction on your transfer duty receipt for purposes of this creation of this negative personal servitude will not be the date of transaction on which the property was purchased. It will be the date on which this negative personal servitude was accepted by the enforcer thereof. So you, in such a transaction, will have two transfer duty receipts. One for the purchase of the property, or one for the sale of the property, and one for the acceptance. The one will have the date of sale as the date of transaction, and the other one will have the date of acceptance of the negative personal servitude as the date of transaction. It will never be able to be the same date, if you understand what I mean, because the date of transaction will always be prior to the date of acceptance of the condition that is created in the power of attorney. So please check your transfer duty receipts when creating negative personal servitudes in favor of third parties. Extending clauses and diagram deed references. Ladies and gentlemen, Conference Resolution 21 of 2016, and I can only explain this Conference Resolution by way of an example. If your property was transferred for the first time from a general plan, let me by way of example say you are transferring Earth 850 Waterkloof Rif extension 48 to your client, and it is depicted on a general plan. Your extending clause will be, as will more fully appear from general plan, number so-and-so, and lastly held by deed of transfer. Let's say you later subdivide that Earth 850. What's going to happen now when you subdivide? You have to lodge what we call a parent diagram or a mother diagram, because you cannot subdivide from a general plan. So you first have to get a mother diagram for Earth 850, and then you have to get a portion diagram or a subdivisional diagram for the portion 1. So your extending clause for portion 1 will now read, as will more fully appear from diagram so-and-so, and lastly held by that deed of transfer. If you thereafter transfer the remainder of Earth 850, which extending clause previously read, as will more fully appear from general plan, and lastly held, you cannot refer to the general plan, because the general plan has now been superseded by a mother diagram. So that extending clause of your remainder will read, first transferred and still held by that deed of transfer with diagram, not number so-and-so, not attached here to, because that diagram was never attached to it, it relates thereto. Instead of using the general plan, you substitute it with the mother diagram. So, in future, when you're transferring a remainder of an earth and your extending clause refers to a general plan, red light, red light, red light, 41B, 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 amend your new deed to bring it in line with this practice so that it refers to the diagram and not the general plan. Also take cognizance of the fact, if your extending clause is wrong and you are doing a transaction, you, the conveyancer, can rectify the extending clause with an application in terms of section 4.1. You can just not bring it under oath. You're bringing it in terms of the authority afforded you in terms of the power of attorney of the transaction that is simultaneously registered with that transaction. I hope that makes sense. And I know extending clauses is a problem for all conveyancing typists, all conveyancers, all paralegals. And guys, I want to say to you that the majority of the rejections in the deeds office emanate from incorrect extending clauses. And this just brings us one step closer to further rejections that is going to be picked up if we do not apply this practice correctly. Application of section 38 to lost bonds. I think I've touched on this already. If your deeds office copy of your bond is gone and your client's copy of your bond is gone, the 2007, the ripple effect. What do I have to do? Now, in the past, in the Pretoria Deeds Registry, they allowed us to bring an application in terms of section 38. Conference has now decided no ways can you apply section 38 because section 38 refers to a title deed of land. So what do you have to do? You have to cancel that mortgage bond in terms of regulation 6811 capital B. Remember, there's a new regulation brought in to cancel a mortgage bond where the title deed, not the title deed, the mortgage bond of the deeds office and the client's copy is lost. So you're going to cancel the mortgage bond for both lost titles, or I can call it titles, and then you have to register a new mortgage bond. But remember, your financial institution or your mortgagee is once again at risk. It's good enough to tell him cancel and re-register. Section 88 of the Insolvency Act, 6-month period. Tell your financial institution, if we're going to cancel this mortgage bond and we're going to re-register the mortgage bond, you're at risk for 6 months. Shouldn't we go to court? That is something that we have to bring to the attention of the financial institutions. I've discussed this at length with the Registrar of Deeds Pretoria, and Ms. Gwangwa has actually said to me, this is a matter that we have to take to the regulation board of the registrars to make them aware that it's not that easy just to cancel and re-register. There are risks pertaining to the cancellation and re-registering. So please take cognizance of Section 88 of the Insolvency Act and note that Section 38 of the Deeds Registries Act cannot apply for the substitution of a lost mortgage bond if the deeds office copy is also lost. I don't think this is a new practice. I think it was just a substantiation of an existing practice, but the registrars have once again confirmed that if you're transferring a section and ceding an exclusive use area, and you're not doing it in terms of a cession and a transfer, but you're doing it in terms of an application in terms of Section 45, you can do a Section 45 on the exclusive use area as well. So they said the provisions of Section 45 for the transfer of exclusive use areas or sessions may be applied. However, nothing prohibits you from doing a formal session thereof in the form of a notarial session. So this practice, nothing has changed with the practice. I think it is just a confirmation of an existing practice, which was confirmed in the past by a Chief Registrar's circular as well. A bit of relief here, guys. Sectional title mortgage bonds, as you know, has an annexure attached to it. And believe me, I have found how many times that when we get the mortgage bond to cancel the mortgage bond, somebody has taken that annexure because they said mortgage bonds cannot have annexures, and they've taken the annexure and they've thrown it away. And now I've only got the mortgage bond and I haven't got the annexure. Can I cancel a sectional mortgage bond if it is incomplete in the sense that the annexure is not attached thereto? And hallelujah for this. Registrars at the conference said, yes, you can cancel it. You do not need the annexure to cancel the mortgage bond. However, should you want to cede that mortgage bond or do any other act of registration like a substitution of debtor or a part payment or a release or whatever the case may be, and the annexure is not attached thereto, then you have to bring an application in terms of Regulation 68 to get a new copy of that mortgage bond. And now, the fear that comes up, the client has lost his copy and the deeds office copy is gone as well. What must I now do? Now I must cancel the mortgage bond and re-register a new bond before I can cede it or release or whatever the case may be. And now I'm at risk with Section 88 of the Insolvency Act again. So, yes, beware this position, but a bit of relief that I do not need the annexure if I am going to cancel. I only need it if I'm going to do other acts of registration. Item 22, sectional title plan numbers. Ladies and gentlemen, this practice, there was not uniformity in the 10 deeds registries. I hope you do know that there's going to be 11th deeds registry in Polokwane for the province of Limpopo on the 3rd of April. However, that is just by the way. This practice, which is confirmed by Conference Resolution 26 of 2016, says the following. If you're doing an extension of a section, meaning you're extending your floor area of your section, and thereafter you register a mortgage bond or you transfer that section, you cannot refer to your old SS number in your property description. You must you must disclose the new SS number that was afforded the sectional plan of extension of the section in your property description clause. In the past, we used the old SS number and there was just an endorsement placed on the title deed. Now, in future, you always have to refer to the SS number. And remember, this is only in respect of extension of sections. If you're doing a consolidation or a subdivision or extension of the scheme, you're still referring to the old SS numbers. So, look at Regulation 23(1)(b) of the Sectional Title Act, read together with Conference Resolution 26 of 2016. 23, item 23, error in your schedule of conditions. Now, this is once again sectional titles, ladies and gentlemen. We have a schedule of conditions which is procured when we open our sectional title register. That becomes the title of our sectional title scheme. If it later transpires that there's an error in the conditions contained in that 11.3b schedule of conditions, the registrars have said in terms of 27 of 2016 that the body corporate can bring the application, or if the body corporate has not as yet been established, the developer can bring an application in terms of section 4.1b to rectify that error. However, it can only be rectified if all interested parties consent to that amendment. And guys, do you know who all interested parties are? All bondholders and all owners of sections, owners of real rights of extension, etc., etc., etc. In a small scheme, no problem. In a scheme in excess of 100 sections, I will never be able to get all the bondholders' consents. Never is a fairly wide term, most probably possible, but it's highly improbable, and it will be highly improbable to get every owner's consent, because one owner is going to say no. And what do I have to do then? Section 41B says I have to go to court. Guys, also a situation that to my mind is totally untenable, not capable of being exercised. And this is Alan West speaking. I don't think that legislation should be interpreted and applied to make it impossible for it to be applied. So once again, there's no cutoff date here for all the bondholders' consents. There's no cutoff date for the owner's consents. So we'll never be able to get this through the Deeds Office. And I'm going to appeal to the registrars of deeds to really look at this item again and to see it from a practical point of view. And you know, for more than 40 years, I sat on the other side of the desk and I interpreted the legislation strictly by the book. It was black, it was white. There was no gray areas. But believe me, sitting on the other side of the table now, it's not always black and white. It is sometimes you have to look for a practical solution to a problem. And here, I can't find the practical solution to the problem. And that is why this was taken to the conference to say, conference, this is the problem that we're sitting with. Come up with a solution so that Batu Pele can be applied in our day-to-day conveyancing practice and procedure. Let's hope sanity will prevail at some point in time. Item 24, and that is Conference Resolution 29 of 2016. They once again went back to conference and said to conference, if you have a real right of extension, which has not lapsed yet, can I register a notarial lease agreement in respect of that right of extension? Now guys, let's just look at this. Remember, many of these real rights of extension is what we call plot and plans. They opened a sectional title scheme. They opened a sectional title register with 2 insignificant sections, and they subdivided the rest of the common property into real rights, real right 1, real right 2. And they sold those real rights, and the person built on that real right of extension, but he hasn't exercised that real right of extension yet, meaning he hasn't incorporated it into the sectional title scheme. Now the question was, can you enter into a long-term lease and register the lease over that real right of extension? And the answer is no. You must first incorporate it into the scheme, then it becomes a section, and then you can register a lease agreement in respect of that section. I hope that makes sense. These real rights of extension is creating major problems in practice, because what we find is that the guy's bought a real right of extension, he's built his building on the property, however he hasn't exercised it within that specific period of time, and now because he hasn't exercised it, it reverts back to the body corporate, and the body corporate must re-reserve that real right of extension, cede it back to the holder thereof, and that holder must then exercise the right, which is a costly and a time-consuming issue. So please, real rights of extension, bit of a nightmare, and sometimes we just have major problems with these real right of extensions. I refer you to the case of Anver Properties CC versus N Street Entertainment Enterprises. It's a 2016 case, which provides that agreements entered into by deregistered entities is ab initio void, and cannot, on the re-registration of that entity, it does not revive the contract. So what are we saying? If you're entering into a deed of sale between ABC company and XYZ company, and one of those entities were deregistered because they did not file their annual returns, the contract is ab initio void. Once they have been placed back on the register, a new contract must be entered into. So what are we saying? Before concluding any contract of sale or lease in terms of which a company or close corporation is a party, ensure that that company or close corporation has not been deregistered with CIPC. If the company excuse me, or entity has been deregistered and it's an owner of property, the property becomes bona vacatia. It vests in the state. Only the Minister of Finance, we don't know who that is going to be, but only the Minister of Finance can deal with that property unless the company has been placed back onto the register in terms of Section 81 of the New Companies Act, and in which case the property automatically then revests in the deregistered company or entity, as the case may be. So beware, beware, beware of companies and close corporations that have been deregistered. Amendments to the Sectional Title Act by the Sectional Title Management Schemes Act 8 of 2001. I think you are all aware now that from the 7th of October, the Sectional Title Act has been amended to take out all the aspects governing sectional title management, and that has been incorporated into a Sectional Title Schemes Management Act 8 of 2011, which is being managed by the Department of not Housing, it's I forget the name of the department that is managing it now, but the same department is also managing the CSOS Act, or the Community Schemes Ombud Service Act, CSOS as it's also known. Now, how does this Sectional Title Management Act affect me, the conveyancer, in my day-to-day activities? Let's start with the opening of the Sectional Title Scheme. With the opening of the Sectional Title Scheme, if I am going to lodge amended rules, I have to get a certificate from the Ombud in terms of Section 10.5 of the Sectional Title Management Act, which I must lodge with the Registrar of Deeds. If I'm not going to amend my Sectional Title Management rules or conduct rules, and the statutory rules as taken up in the Sectional Title Schemes Management Act is applicable, I do not have to get a certificate from the Ombud. I am just going to give a certificate from a conveyancer certifying that the rules as contained in Annexure 1 and Annexure 2, namely the management and conduct rules in the Sectional Title Management Schemes Act, is applicable to this scheme. So only if I change my rules on opening of the scheme do I need a certificate from the Ombud. Otherwise, conveyancer certificate. Previously, you will remember when we're opening a scheme and we're transferring the first section, we used to lodge a Form W. That is, which gave proof, or is proof that the body corporate has come into existence. In terms of the Sectional Title Management Act, there's no Form W anymore. There's a certificate given in terms of Section 2, which that's in terms of Section 2 of the Sectional Title Schemes Management Act, and you, the conveyancer, must lodge that certificate in terms of Section 2 in triplicate, and the registrar signs that. One goes to the Ombud, one goes back to the body corporate, and one is filed on the file. So there is a change in practice. So those are the two major changes that this Sectional Title Schemes Management Act 8 of 2011 brought to our day-to-day practices. In your 15B3 certificate, preferably do not refer to the act which gave rise to the coming into operation of the body corporate. If you're going to give your 15B3 certificate, you're going to say the body corporate is in existence and all money is payable to the body corporate has been paid or provision has been made for the payment thereof. If you're going to refer that the body corporate has come into operation, there's two schools of thought. One school of thought says you must always refer after the 7th of October to Section 2. There's another school of thought that says after the 7th of October, you must determine if it was incorporated in terms of the new Sectional Title Schemes Management Act or the old Sectional Title Act or the 1971 Sectional Title Act, which then becomes an untenable situation. So what are we saying? The Chief Registrar of Deeds has issued a directive to the examiners stating it is not peremptory to refer to the provision of the Act which gave rise to the coming into operation of the body corporate. So those are the two major amendments, and there's also a Chief Registrar Circular, I think it's Chief Registrar Circular 13 of 2016, which elaborates fully on the change in practices. And I'm not going to go through them item for item. You can read this because it makes for interesting reading. I'm just waiting for my next slide. Guys, another court case that I want to bring to your attention is also a 2016 case, and that is the case of Donay Homeowners Association and another versus Bergwater Plaza CC 2016. All that this case has confirmed that if your memorandum of incorporation of your homeowners association clearly sets out that the homeowners association will not be liable for any contribution to the homeowners association levy fund, the homeowners association at their first meeting cannot go and unilaterally amend the MOI to say, homeowners association, you will be liable for all your unregistered urban. So what are we saying to one another? We're saying caveat emptor, caveat emptor, caveat emptor. When I buy into a cluster housing scheme and there is a homeowners association, I must determine from the MOI of that homeowners association or the constitution, if it's not a Section 10 company of the New Companies Act, whether the homeowners association is going to contribute. Failing which, the poor owners are saddled with all the costs to maintain the common property, the security, etc., etc. So this case has just elaborated once again on the practice and procedure which provides who is liable for levies in a homeowners association. But there's another case, and I think I've referred to it in this article. I say the above case must not be interpreted as authority that all developers are not liable to contribute to the levy fund. In the case of Heritage Hill Homeowners Association, there the judge clearly said, and that was in 2013, that the developer is liable for levies on all untransferred urban, because it was not categorically set out in the MOI. So just take cognizance of that as well. I refer you to another case, and this is something that lies very near to me because there's so much confusion amongst the people outside there with regard to anti-nuptial contracts. And it was once again substantiated and elaborated and confirmed by the case of S versus S 2015. Now, ladies and gentlemen, when I come to you and you, my conveyancer, and you transferring my property and you ask me to prove my marital status, my anti-nuptial contract is not proof that I'm married out of community of property. It is proof that I've entered into an anti-nuptial contract. You have to get a marriage certificate as well. you have to determine if the antenuptial contract was entered into prior to me concluding my marriage. If it was subsequent thereto, I married in community of property. Not only that, ladies and gentlemen, you have to determine where I was domiciled when the marriage was entered into. If I was not domiciled in South Africa, although I've entered into an antenuptial contract, that does not make my marriage out of community of property. It is a marriage which is governed by the laws of the country where I was domiciled. So what am I saying? Antenuptial contract, marriage certificate, proof of domicile. Then I take all those facts and I determine, was the antenuptial contract registered within 3 months of date of attestation before the notary? If not, in community of property. Was it concluded prior to the marriage? If not, in community of property. Where was I domiciled? I wasn't domiciled in South Africa. I'm not married in community of property. I must be described as married, which marriage is governed by the laws of the country where I was domiciled. And so I can continue with this. An antenuptial contract, the court has held, will be effective inter partes. It will not be valid against third parties. So please read this case, read what I have alluded to with regard to the effect of an antenuptial contract which is not valid. And this brings me, and really time just does not permit us to discuss customary law and customary marriages. But if you are a notary concluding antenuptial contracts of the indigenous people of South Africa, and they come to you and they want to enter into an antenuptial contract, ladies and gentlemen, you have to, before you attest that antenuptial contract, you have to determine if they have not entered into, celebrated, and negotiated a customary marriage. Because if they've entered into and celebrated and negotiated a customary marriage, which is the customs and usages traditionally observed amongst the indigenous people of South Africa, then they married in community of property, and then they cannot enter into an antenuptial contract ex post facto their marriage. Although they want to enter into a civil rights marriage now, they can only convert the customary marriage from in to in. They cannot convert it from in to out by just entering into an antenuptial contract and getting married before a minister or home affairs or whatever the case may be. So once again, customary law is a topic on its own, which I think at some point in time, ladies and gentlemen, it must come from you, but a proposal must be made that we have a webinar just on customary marriages and the effect of customary marriages and how it affects you, the conveyancer. Because I can promise you, we on an often and an ongoing basis get clients coming to us stating that they haven't registered their marriage with Home Affairs, and then please just describe me as unmarried. If you describe that person as unmarried in the mortgage bond is ab initio void if a customary marriage was concluded. Because Section 4(9) says the non-registration of the customary marriage does not affect the validity of the marriage. I hope and I do trust that I'm preaching here to the converted and that you are applying the practice of customary law, customary marriage correctly in your day-to-day conveyancing. The NCA, the National Credit Act, new registration requirements. I just thought that I'd have to bring this to your attention, that in terms of Government Gazette 39663 of 4th of February 2016, the threshold of for purposes of registering as a credit provider has been brought down to R0 or no rand. Previously, there was a 500,000 threshold. So, guys, if you are registering what we call a kustingsbrief, bond for the balance of purchase price, simultaneously with the transfer of your property, please take cognizance of the fact that if your mortgagee does not register as a credit provider in terms of the National Credit Act, that bond is ab initio void. Look at the definition of large agreements, look at the definition of credit providers, and note that even if it's now for 100,000 Rand, it is still, even if it's for 1,000 Rand, you must still register as a credit provider. Trust names. This is a major problem in the deeds registries because we never knew what the correct practice is that the deeds office applies with regard to trust names and the word the. Now sometimes you get the Allen West Family Trust or you get Allen West Family Trust. So when must you use the in the part of the name, or when can you omit it from the part of the name? And in terms of Pretoria Registrar Circular 19 of 2016, which was confirmed by the conference, you will have yourself led, conveyancer, by the trust deed. If the trust deed says the trust will be known as ABC Trust, then you cannot call it the ABC Trust. It will be power of attorney afforded by the small letters ABC Trust. If it is power of attorney afforded by the, then you'll include it as part of the name in capital letters, the ABC Trust. So what am I saying to you? With trust names, have yourself led not by the letters of authorization. The registrar said by the trust deed. And if your title deed from which you are transferring it is incorrect, you'll have to obviously lodge proof of the correct name. And I see here I said the said amendment can be brought by the conveyancer appointed in the power of attorney provided the necessary letters of authorization are lodged. Please just amend that. That is not the letters of authorization, because they said have yourself led by the name of the trust in the trust deed. So you'll have to lodge a copy of the trust deed. Please just rectify that for future practice and procedure. I wanted to just reiterate the provisions of Section 42 of the Immigration Act, and for you to differentiate between a foreigner and an illegal foreigner. Now, ladies and gentlemen, a foreigner is somebody that's not in South Africa or somebody that's in South Africa that is legally in South Africa. And if he's a foreigner and is legally in South Africa, until the new legislation comes, which the state president and the minister Nkwinti has spoken about most recently again, until that happens, a foreigner can buy the whole of South Africa. However, an illegal foreigner, that is somebody that is not legally in South Africa, cannot acquire any property, cannot even lease property in South Africa, because it is a criminal offense. And there I refer you to Section 42, read together with Section 43 of persons abetting an illegal foreigner in acquiring property. So please take cognizance of the provisions of the Immigration Act, specifically Section 42. Read my summary as well as the provisions of Section 49(6), which says any person who contravenes the provisions of Section 42 shall be guilty of an offense and liable on conviction to a fine or imprisonment not exceeding 5 years. So we have to determine whether this person that we are entering into the lease agreement and registering the lease agreement, and you're going to say, is that me? You are registering the lease agreement, you are abetting, and that's what the Act says, or if you're transferring, you are also enabling the person to acquire the property, and you will also be liable to a 5-year imprisonment. The signature of parties, maybe I thought it prudent to bring this to your attention, because I got a rejection from the deeds office the other day where the person signed the deed by printing his initials and surname. And the examiner said to me, this is not his signature, he printed his name, and a big fat R was put on my deed. And I said, that can't be. I mean, you know, what is a signature? And then I did research, and the research clearly says there's no definition of a signature in deeds or documents in our law. In general, there's no particular mode or form required, provided in person intends it to be his signature. And that could even be a cross, ladies and gentlemen. And if it's a cross, if I'm putting my signature in the form of a cross, then it must be added to by a certificate from a Commissioner of Oaths. That is in terms of the Commissioner of Oaths Act 16 of 1993. The same as when your client cannot sign or cannot even make a cross, and I hope he's at his full positives, and then you take his left thumb or his right thumb and you put it in ink and you place it on your document, then a Commissioner of Oaths must also add a certificate that that is the left thumbprint of Alan West as such. So please, I just thought I'd bring this to your attention, specifically with regard to the making of a mark as well as the thumbprint, so that you know in future how to apply that. Compliance with suspensive conditions. You know that Section 92 of our National Credit Act, over and above the cooling off period for the sale agreement in terms of the Alienation of Land Act, Section 92 of the National Credit Act provides as follows. A credit provider must not enter into an intermediate or large agreement unless the credit provider has given the consumer a quotation in the presented form setting out the principal debt, the proposed distribution, the interest rate, other credit costs, the total cost, etc. And then, subsequent to the quotation having been received, the client has 5 business days. Now, why am I bringing this to your attention? I'm bringing this to your attention because in the majority of the deeds of sale that I have seen and which has been opened before me, it says that a suspensive condition with regard to the getting of a loan for the balance of the purchase price or the purchase price will be deemed to be complied with once the loan has been afforded. Not true. Not in terms of Section 92. Not when the loan has been afforded, when the loan has been accepted, and obviously the guy has 5 days in which he has to accept it, otherwise he can decline that offer. Obviously, he'll have to have good reasons why he's declining the offer. So, what am I saying to you? Please just revisit if you are preparing deeds of sale for your estate agents, to say that the suspensive condition is not complied with on when the loan has been afforded or granted. It's when it has been accepted. Obviously, it could be rejected within 5 days as well. I just thought that I'd bring that to your attention. Cancellation of sale agreements and the retention of deposits as a penalty. Ladies and gentlemen, I refer you to the case of Matthews versus Pretorius, 1984, as well as the case of, I just want to get the other case that I referred to here. It was also confirmed now by the Constitutional Court in 2016, sorry, 15. I didn't refer to that case. Where I'm coming from with this is that if your deed of sale has a clause in it that the deposit which has been paid, if the purchaser is in breach, can be held or paid over to the seller as a type of penalty clause. In terms of the case law, which has been confirmed now by the Constitutional Court, this cannot be. Once again, you cannot take the law into your own hands. It can be done by virtue of an agreement. Alternatively, the matter must go to court, and the court must decide what is the penalty that is payable for damages in respect of this agreement or this cancellation of the agreement. So I say, from the said case law and the constitutional case and the provisions of section 3 of the aforesaid act, sellers or their agent, you the conveyancer, cannot take the law into their own hands. The penalty must be agreed upon between the parties, preferably in writing, or the court must be sought to quantify the amount. So just once again, revisit your deeds of sale to determine whether there isn't this penalty clause in your deed of sale. Item 38, authentication of documents. Ladies and gentlemen, you won't believe, almost on a weekly basis, I get somebody phoning me or emailing me and saying me, Alan, my seller or my purchaser is sitting in Sydney or Brisbane in Australia. And do you know that the nearest ambassador is 3,000 kilometers away? And it's just not possible to get this document signed before them. And then I say, is Australia part of the Hague Convention? Yes. Then why do you want to go to the ambassador? You can do it in the form of an apostille. So, guys, I just thought I want to bring this to your attention again, that we must look at Rule 63. There are 5 countries that can be done before a notary. All the other countries must be done before the foreign mission or before the ambassador, unless that country is a party to the Hague Convention with South Africa, in which case it can be done in the form of an apostille. So please, I have, if you go onto our website of McRobert Attorneys, I have a article, written authentication of documents. I've given examples of how the authentication certificate or the Rule 63 certificate must be set out. Please do yourself a favor and do read that. Item 39 is the withholding of tax in terms of Section 35A of the Income Tax Act. And once again, just to perhaps refresh your memory, that Section 35A, subject to the threshold of 2 million rand, if your seller is a non-resident, you, the conveyancer, must withhold a certain amount of the purchase price. Namely, if it's a non-resident, is a natural person, 5%. If it's a company, 7.5%. If it's a trust, 10%. And it must be paid over to SARS within 14 days after the date on which the money was so withheld. And there are other provisions of the paying over and the directives that can be obtained. Now, a question that often is posed to me with regard to Section 35, who is a non-resident? How do I determine whether my seller is a non-resident? Ladies and gentlemen, please go to the Income Tax Act. Look at the definition. There's a definition of a non-resident. So you'll have to get the necessary documentary evidence that your seller is not a non-resident. Because, once again, if you do not withhold this amount, and it later transpires that he was a non-resident, you, as the conveyancer, will be held liable in your personal capacity for, and thank the Lord for small mercies, that it will only be to the maximum amount of which you would have earned from this client. The estate agent and you will both be liable to the amounts that you would have earned in your profession for the services that you rendered. So we say where the seller is a property transaction, is a non-resident, the estate agent, if any, and the conveyancer who assists in administering the transaction for a fee, the section phrases, who is entitled to payment of any remuneration or payment, must each notify the purchaser in writing before payment is made to the seller that this section may be applicable. And just read what I have referred there further with regard to the withholding of tax and your liability. Item 42, burial sites and visitation to graves on rural land. I wrote a full article on this because there is so much uncertainty of burial sites on farm property, and the rights of of persons who have buried their ancestors there, and for purposes of visitation rights, specifically, ladies and gentlemen, with the crime, etc., in the rural areas, farm properties, people don't want you to come onto their farm to visit the grave sites. And what rights do I have? I want to go put flowers on my father's grave. Have I got the right? And I thought, just to bring this to your attention and to bring to your attention the provisions of Section 6 of the extension of Tenure of Security Act 62 of 1997, which makes it a real right, not a personal right, which is enforceable against the owner of the land. However, in my conclusion, I say, although it's a real right, how does one prove a real right? That's very difficult. So in my conclusion, I said, from the aforesaid Act and the case law referred to, burial and visitation rights are real rights, I've said that, which are capable of being registered against the title deed. They do not have to be registered to be enforceable, but to protect the interests of all parties, I strongly advise to have such rights registered as personal servitudes so that somebody cannot withhold the consent or deprive somebody the right, whether it is a personal servitude or not. So please just look at that and take cognizance of that, and if there is uncertainty, have it registered against the title deed. Ladies and gentlemen, that brings us to the end of the webinar. Obviously, we have 20 minutes now for questions and answers. I only have so much time. I would love to have another 2 hours for questions and answers. However, I realized that I went through this webinar items very fast. You will be receiving a copy of the handout in hard copy, and you will also receive via email, you will receive this presentation that you can listen to again in case you have missed something that I have mentioned during the seminar, or if you just want to revisit something at some point in time, or give it to your paralegals to listen to at some point in time. The floor is now yours, and you can now obviously write down your question, and I will read out your question to all the listeners of the webinar and try and answer it as comprehensively as possible. If I cannot give you the answer now, I will do my necessary research and get back to you at some point in time. Antoinette, I'm going to start with you. I know the questions are flooding in. There's Antoinette. She says, foreign trusts, if agreement entered into before the trust has been registered with a master, ? Antoinette, there's not a definitive answer on this, but I want to equate it with a case law and say the trustees of a foreign trust in South Africa do not have the authority to enter into any transaction on behalf of that trust before they've registered the trust deed with the master and they've been issued with letters of authorization. So yes, I would be very hesitant to say, Ahmed, they entered into the contract, so the contract is valid. I would say Section 8 of the Trust Property Control Act, the same as any other trustee, I would say the contract is also ab initio void. That's Alan West speaking. There's not a case law on it, okay? Louise Snyman Horsford, I'm opening a sectional title register. Do I need a certificate from the Ombud or only the conveyancer certificate in place of letter? As I said, Louise, if you're not changing the rules, you need no certificate from the Ombud. But you cannot give a certificate in terms of Section 11.3e because Section 11.3e has been repealed. So you're only going to write there, instead of conveyancer certificate in terms of Section 11.3e, you're going to say conveyancer certificate. And the wording is going to be exactly the same as your 11.3 certificate that you gave in the past. I hope that makes sense. Zinat Hussein, foreign divorce order, an authenticated copy must be lodged. What if the divorce order is not in English? Would you need a sworn translation and that translation to be authenticated. Zinat, you will obviously need a sworn translation, but it can be from a South African sworn translator or whatever you want to call it. That does not have to be authenticated as well. If it has been translated in some other country and signed in Guatemala, then obviously that will have to be authenticated as well, because it is a foreign document. So I hope that answers your question. So if I got divorced in China and it is in Chinese, the deeds office would not be able to determine whether the rights of third parties have been prejudiced or have been prejudiced by this divorce agreement. You'll have to get a sworn translation. Yes. Yasmin, land claim, busy with transfers to trust. Trusts were registered after settlement agreement. Are the transactions valid? Remember, with regard to land claims, the Land Claims Act says you must disclose that in your deed of sale. If you have not disclosed it in your deed of sale, the transaction is ab initio void. So there I want to refer you to the Land Claims legislation, which obviously refers that if it is not disclosed. Look, this has got nothing to do with the deeds office, because they don't even know that there is a land claim, or if there's no land claim. That must be disclosed in your deed of sale. Any further questions? I'm waiting for some questions. I'm sure you've got so many questions that it's just not true. And sometimes, guys, many of you think this is going to be a stupid question. I always say there's no such thing as a stupid question. There's a lot of stupid answers, but there's no stupid question. And maybe the question that you want to pose is a question that many other people want to know. If the suspensive condition has been met only once the purchaser accepted the loan within 5 days, it presents a problem. This is Niku that's saying it presents a problem, as in most instances the quotation is forwarded by the bank to the bond attorneys and is only accepted by the borrower when he is called on to sign the bond documents, which is almost always more than 5 days after the loan was granted. Niku, I agree with you, but remember, after the 5 days and he hasn't rejected it, remember that's the cooling off period, and he hasn't rejected it, after the 5 days, it is tacitly as if he has accepted it. So he hasn't got an ad infinitum time. But where I'm coming from is your deed of sale cannot say that the suspensive condition is deemed to have been complied with on the affording of the loan. It is once he's accepted the loan and he has 5 days in which to accept it. After the 5 days, it's tacitly, if he hasn't rejected it, then obviously it is deemed that the suspensive condition has been complied with. Does that make sense? Judy? If the trust was a verbal trust in terms of the common law prior to it being reduced to writing, will an agreement entered into by the trustees prior to the deed of trust being reduced to writing and letters of authority being issued be invalid, since the Trust Property Control Act only refers to trust reduced to writing? Judy, I don't know if you've got my book in front of you. And just by the way, this is just an advertisement flash. All of you that are enrolled for this webinar automatically gets 20% discount on my book. So please just keep that in mind. You can just, if you order the book, you must get 20% discount. I wrote an article on this. I published it in the Day Rebus, and obviously I've taken it up in my book. Oral trust, yes, common law does, and the Trust Property Control Act, if you look at the definition of trust, it says oral trust. Now, the burden of proof here, and if the popo hits the fan, how are you going to prove that this was an oral trust and that it was entered into? This is a defense that can be raised should one want to climb out of the contract. But I agree with you. Our common law, not our common law, a statutory law does allow for a oral trust. And yes, they can enter into it. And then yes, they can register, convert it into writing and register. But where we're coming from is the burden of proof. I don't want to get involved in case law and burdens of proof and to determine whether it's a valid contract. So I'm going to try as far as possible to steer away from that. Okay, Judy, but your question is a valid and reasonable question, and please do yourself a favor, read the article that I published, and specifically with regard to the responsibility of the conveyancer in terms of Regulation 44 capital A. Louise, I know this has nothing to do with the webinar you presented, but can you maybe answer this question? I will try. We are busy with a few estate transfers. The deceased died years ago. The value falls under Section 18.3. Now the transfer selling with a higher value. The master won't accept the Section 18.3 authority and now wants to apply the letters of acceptance. There's a directive, Louise. There's a directive issued by the master, and I've also published that on my MacRobert website, my news, property law news. I've published the directive. The relevant date for the value of the property is the date that the estate, I think the chief master said, the date when the estate was where the person has died, and not the date that you're selling the property. Please just look at that master's directive. And it's good that it doesn't fall under the webinar, but this is a question that many people. So please, there's a directive. It was published, and I have word for word, I've set it out as an article on my website. Go to MacRobert's website, go to Property News, and please see if you can find the directive there. Belinda, is it valid if the purchaser is a private company, however the name is yet to be registered but already reserved? Is the deed of sale valid? Even the New Companies Act makes provision for pre-incorporation sales, and the necessary provisions like the old Section 35 of the Companies Act, you have to obviously ratify that. So you're going to buy the property in a... That's one of the only exceptions, Belinda, that you can acquire property on a person not yet formed. But there's going to be, in my capacity as trustee or authorized agent of a company still to be incorporated. So yes, the transaction, the sale is valid. Louise, you say thank you so much. Okay. Dirk de Tooy, Section 18.3 state, the will stipulates that habitatio for the Wendy house is bequeathed to A. Is it possible to register habitatio without a diagram? Let's go back to my first item, Dirk. A Wendy house, first of all, I want to know, is a Wendy house regarded as immovable property? We cannot register habitatio if it's not immovable property. That's my first point. Whether a Wendy house is immovable, now then we have to now go to our law of things, and we have to find out in edificatio, how is it attached, was there a foundation, etc., etc. If there's a Wendy house and you want to register habitatio and it is immovable property and it's not the only dwelling on the property, I need a diagram. So, Jene Dirk, I want to say to you, steer away from this habitatio over the Wendy house. Just enter into agreement that the guy has. I don't know who's going to live in a Wendy house, but I'm not going to go down that way. Please, a Wendy house, yes, diagram if it's immovable property. Belinda, thank you so much. You say, Alan, you're a star. Thank you so much. I really appreciate that. Stephanie van Niekerk, busy with a transaction where the seller is a South African registered company with a foreign directors. Would the following still be applicable? Stephanie, look, I also here want to ask you, I spoke about the provisions of Section 35A, but when we come to the New Companies Act, and here I want you to refer you to Chief Registrar's Circular 28 of 2013, we must differentiate between a foreign company and an external company. A foreign company is a company that has registered as a foreign country in outside of South Africa, and it's not doing business in South Africa. Then it can acquire property. An external company is a foreign company who's doing business in South Africa, and then it must register as a external company in South Africa with a registration number. So please do yourself a favor, Stephanie. Go to Chief Registrar Circular 28 of 2013. Go look at the provisions of external companies and foreign companies, and I refer you to Section 23 and Section 23 capital A of the New Companies Act. That should answer your question. Leon Etzebeth, similar to the question regarding ab initio voidness of a transaction, will an offer to purchase to be held to be invalid if the court has ordered a curator bonus appointment, but the letters of authorization have only been issued after the offer to purchase has been concluded between the curator bonus and the purchaser. Thank you so much for the webinar. Leon, yes. And you know where this also comes from. There's case law on it. Not off the tip of my fingers, I cannot give you the case law. But you know what's happening. The executor of deceased estates is selling property before he's been issued with the letters of executorship or the letters of appointment. And that brings me back to letters of curatorship. How can you enter into a contract if you have not got locus standi? If you have not got locus standi, that contract is going to be ab initio void. So, Leon, to answer your question in a nutshell, yes, and please look at my book as well, specifically the chapter on estate transfers. There I refer you to the case law, which says that anybody acting in a representative capacity, the contract is not voidable, ab initio void, if not the person has not been issued with a letter of authorization. Is an Act 70 or 70 consent necessary where habitatio is registered over agricultural land where the whole property is subject to the habitatio, since the property is basically just a house with a garden and the whole property therefore subject? Judy, remember what I said right in the beginning? I said you can never register a habitatio over land. You can only register it over a dwelling, because a habitatio is a habitation to dwell in a dwelling. So if there's only one dwelling house on the farm, only one, and that you, the notary, must determine. So, and how are you going to determine that? You're going to get an affidavit from the bare dominium owner, and you're going to get the affidavit from. And if there's only one dwelling house, you do not need a consent. Then if it's longer than 10 years, you still need the consent in terms of Act 70 or 70. That's Chief Registrar's Circular, I think it was 3 of 1971. So to answer your question, if you're registering it, you cannot register it over the whole of the farm. You can only register it over the dwelling, but there must only be one dwelling, not to have a diagram. Judy, I speak very fast, and if I didn't make sense to you now, just tell me you don't make sense. Explain to me again. Durandi, you ask if the rules for a body corporate need to be registered with the Ombud. In what format and where should same be lodged? Very good question, Durandi, and this is maybe one of the new webinars or a further webinar that we have to hold. We've got a Chief Ombud in Sandton. We've got an Ombud in Durban, and we've got an Ombud in Cape Town. If you're in the jurisdiction of Gauteng, you can lodge your rules, your amended rules, with all the accompanying documents electronically and in hard copy with the Ombud in Sandton. He will, or they will, then examine your rules. Remember, the Registrar of Deeds never examined rules. They just filed the rules. The Ombud will now examine your rules and determine whether those rules are fair and applicable. And then the Ombud has said the turnaround time for the giving you the 10-5 certificate that he's going to give for the amended rules is 5 days. And I must say, the Ombud is keeping to his promise. The turnaround time is 5 days. So the body corporate rules gets filed with the Ombud electronically and in hard copy, and then the certificate that is given, you must pick that up from the Ombud in the format of the regulation that it was promulgated in terms of. Durandi, hope that makes sense. Question time, question time. While you're thinking of your questions, the Law Society has just asked me to bring to your attention two things. I don't know if you're aware of the ProxySmart application. ProxySmart is a case that is now, you'll find all the documents on the website of the Law Society, where they want to divide the work of conveyancing into conveyancing work and administrative work, and ProxySmart will be doing the administrative work, and the conveyancer will only do the reserved work for the conveyancer. Now, the Law Society and the provincial law societies are adamant that you cannot separate the conveyancing work from the administrative work, and there is going to be a application to prevent ProxySmart from introducing this. So please do yourself a favor and read the necessary affidavits and documents on your website. And then the Legal Practice Act, we know that that is coming into operation. All the ins and outs of the Legal Practice Act is also on the Law Society's website. Please read that, see how that affects you as a conveyancer. Guys, it would appear as if we've run out of questions. As I said, it was really nice to share this information with you and to have you here on a Monday afternoon so that you can, just sharpen your sword on new aspects. I think personally this must be an ongoing thing. I would like to do a webinar on customary marriages, customary law, as well as the new Sectional Title Management Act and the CSOS Act in future. But it mustn't come from me. You out there should request this from the Law Society, and I will be more than willing to abide. I wish you a good night and I want to say a prosperous 2017, and I hope all the conveyancers drive Porsches the next time I see them. A very good night to you all.